in terms of thinking about practical things that people can do. On a larger scale, one of the things that became evident yesterday is the fact that we have a number of states like Utah who are suddenly confronted with same-sex marriage law coming from the Supreme Court that they didn't choose themselves, but that is going to create a range of legal issues. I think we had the benefit of having Senator Adams here with us yesterday, the discussions from Robin and others, sensitizing us to the range of issues that are going on, and that's certainly an area that people around the country are going to have opportunities to talk about, to get involved, to help formulate and think about laws, to help, I think about what does constitute fairness for all, how one can make and find better solutions than constitutional minimums, the challenge of making sure that religious freedom protections are broad and strong. Let me just say one thing that I think sometimes is not obvious. The fact that you have a freedom of religion right to do something doesn't mean you will necessarily do it, right? I believe strongly in the rights of people who have strong conscientious objections to participating in any way, shape, or form in kinds of conduct that they do not want to condone or to be complicit with. On the other hand, I'm also conscious that we have a greater obligation to love our neighbor, and I think in a lot of practical cases that may in fact override, so that there may well be bakers or photographers who object to same-sex marriage, but as they weigh what they're going to do, will feel the obligation to love their neighbor more strongly. Or think of Hobby Lobby. I am deeply sympathetic to the rights of the Greens, who I've personally met, not to provide coverage because of certain kinds of things that they think would constitute abortion. This is very serious. Different religious traditions have different complicity rules. I suspect that Mormons don't have the same exact sense of obligations. I don't think anyone has questioned the right of the Marriotts to have temple recommends, despite the fact that you can get alcohol in their hotels. So I think it's important that on the one hand we understand the importance of fighting for religious freedom rights, but that we also understand that one of the privileges of liberty is that you don't have to push rights to the extreme. At the same time, it's very important that the state not be pushing people beyond their extremes. So I think that's worth bearing in mind, because sometimes we get so focused on the rights that we forget it's really a liberty, really leaves us room for choice. It doesn't compel choices. I was also struck as I was reading through some of the things that we can do. I have a longer written version of Matt Richards' talk. He's done a number of things. And I was struck reading through that last night that one of the things we can do is pray. And with that in mind, let's have an opening prayer.
Our Father in heaven, we bow before Thee this morning, grateful for the privilege we have of participating in this event. We're grateful for those who have organized this conference and who are participating in it. We're grateful for this land. We're grateful for the Constitution of the United States and for the institutions of government that provide a framework for us to live and to prosper. We are mindful that this is a diverse land, and diversity brings challenges and opportunities. We pray that as we listen and participate today, that our hearts and minds will be opened to ways in which we can contribute to acceptable solutions to the challenges facing our country, in religious liberty in particular. Please help us to be part of the solution, not part of the problem. We are grateful for all that we have, and we give thanks to Thee and pray Thy Spirit to attend us in our deliberations today. In the name of Jesus Christ, amen.
Amen.
So at this time, I'll simply turn things over to Bob Smith, the moderator of this panel. Bob is the managing director of our center, and he's a hardworking and very loyal soul working in these areas. But let me turn things over to him for this session.
Well, we're excited this morning to have this panel to discuss the Obergefell decision. And this is obviously something that's been on many people's minds and wondering about it. And we have some wonderful experts who will guide us through the decision and its implications. Each of our panelists are really a profile in courage in their individual lives in upholding religious freedom. Let me just start with Jean. Jean has an illustrious career as an appellate litigator, having clerked at the U.S. Supreme Court, graduating from the Yale Law School with distinction, and then continuing his practice primarily at the federal appellate courts and at the U.S. Supreme Court. Much of those decisions that he's worked on have involved religious organizations and their needs. And you may have known from newspaper accounts that about a year and a half ago, he left a very large international law firm to come to Utah and receive an appointment as a special assistant attorney general to assist with the Kitchen versus Herbert case, the first federal decision that mandated same-sex marriage under the federal Constitution. And he has spent a lot of time working on the same-sex marriage issue, both for Utah, for Idaho, and in other capacities. Alexander Dushku is a shareholder and member of the board of directors of the Salt Lake law firm Curtin and McConkie. He has also had great distinction in his academic career, and in coming to Curtin and McConkie has been in the constitutional group that primarily represents the LDS Church in these kinds of issues. Alexander mentioned that he's been working on marriage issues for close to 20 years and has written many briefs, and including the briefs in these cases that were Obergefell and many of the other same-sex marriage cases that have been occurring around the country on behalf of the church, and assisting with many other religious organizations in their brief writing as well. Robin needs little introduction after our experiences with her yesterday and her insightful comments, but I think it's worth mentioning that in this regard with marriage, she's had a long history of working on family law issues and religious freedom issues, and so the confluence of those two things is really her sweet spot, and we look forward to her expert comments today. I think it should be noted that the very first free exercise case in the United States dealt with marriage. It dealt with polygamy in Utah, the Reynolds decision. And so marriage has been a part of the religious freedom framework from really the inception of at least free exercise jurisprudence. And so this is a topic that, even though we're dealing with marriage, it has such an implication on our religious feelings. As we learned yesterday from Matt, religious freedom is important in part because it goes to the core of our identity, and part of that core is our marriage decisions. And so these implicate very sensitive topics, and we're grateful for our panelists who will elucidate those for us. Now, just so you understand, we want to have lots of time for questions. We've asked, however, for Gene to give us an overview of the decision so that we understand its history and background and how the decision was decided. And then he will illuminate some of the religious freedom risks that are possible because of the decision and how it was decided. Alexander will give a deeper analysis of the risks and the cultural implications of the Obergefell decision. And Robin will discuss some of the current reactions that we've already seen in response to the decision, and some of her recommendations and principles that we might consider as we consider dealing with that decision. So with that, we'll turn it over to Gene.
Well, good morning. It is an honor to be with all of you and to be able to participate in this conference. I'm going to begin with a question, whether anybody in the audience knows the proper pronunciation of the name of this case. How would you pronounce it in German? Obergefell. Okay. I was a French-speaking missionary, so I'm inclined to say Obergefell. But we'll go, since Cole was and is an expert in German, maybe I'll try to say Obergefell unless somebody objects. Well, since the decision 10 days ago, I've been asked more than a few times whether, having made some professional and financial sacrifices to defend traditional marriage for the last year and a half, whether I felt devastated to see those efforts come to naught in the decision 10 days ago. And I can't deny that the decision was an enormous disappointment. I think it's a tragedy for democracy. I think it's a tragedy for federalism. I think in the long run it is a tragedy for children and ultimately for society. But I have no regrets about taking on the cause or the way we approached it. I have always believed that whether we won or lost the case, those of us who believe in traditional marriage needed to try to leave a persuasive witness of the human and social risks of redefining marriage as a genderless institution, in hopes at least that other nations and perhaps future generations will avoid what I view as a colossal mistake, and perhaps to lay the groundwork for a future Supreme Court to overrule the decision that we got 10 days ago. And certainly the four dissenters, I think based on their dissents, would not hesitate to overrule Obergefell if there were an opportunity to do that after a change in personnel on the court. I also felt that it was important to defend Utah's marriage laws and Idaho's and the others that I was involved in defending in a way that doesn't depend upon any particular religious or moral views about homosexuality. I have those views of my own, but I've always felt that traditional marriage can and should be defended in a way that an atheist or an agnostic would find the defense perfectly sensible and acceptable. And I've also felt that it was important to defend those laws in a way that avoids casting any aspersions, either directly or indirectly, on gays and lesbians or on their motives for seeking marriage. Now, going forward, I still think that those of us who believe in traditional marriage should do everything reasonably possible to overturn Obergefell, or at least to mitigate its effects. And as a member of BYU's Board of Trustees recently reminded us, this is from Elder Oak's conference talk a few months ago, he said, "Even as we seek to be meek and to avoid contention, we must not compromise or dilute our commitment to the truths that we understand. We must not surrender our positions or our values." At the same time, I don't think it's right or productive to rail against the Supreme Court majority or our opponents, and especially not to impugn their motives. Here again, I think Elder Oaks gave us some very wise counsel when he said that followers of Christ should be examples of civility. We should love all people, be good listeners, and show concern for their sincere beliefs. And though we may disagree, we should not be disagreeable. Yes, we should be wise in explaining and pursuing our positions and in exercising our influence, but when our positions do not prevail, we should accept unfavorable results graciously and practice civility with our adversaries. And I think, especially in light of the religious freedom issues that we'll discuss in a moment, civility is going to be even more important in this debate. And so today I'd like to briefly describe Justice Kennedy's opinion, and especially his attempts to minimize the risks to religious freedom that he knew his opinion would create. And then I'll describe some of the main religious freedom problems that the decision nevertheless creates or exacerbates, and I'll conclude with a few words about what we can do about those inevitable conflicts, and then the other panelists will have some additional wonderful ideas for us as well. Now, contrary to the argument that we often hear, how many of you heard people say that, well, same-sex marriage doesn't really affect religious freedom, right? If you don't like same-sex marriage, don't marry somebody of the same sex, right? How many of you heard that? Well, Justice Kennedy obviously recognized that there is at least a potential for enormous conflict between institutionalizing same-sex marriage and religious freedom, and that conflict arises from the fact that all three of the Abrahamic religions, Judaism, Islam, and Christianity, and all other major world religions have for millennia taught that a man-woman union is not just nice, but that it's central to the very idea of marriage. Now, a lot of people try to compare opposition to same-sex marriage with opposition to interracial marriage, and they say, well, those religious objections to interracial marriage, they all went away, and religious objections to same-sex marriage will go away as well. Here's a picture of the famous couple that was at issue in the Loving versus Virginia case. The fundamental difference, though, is that, and I went to high school in the South, and so I would occasionally hear people make religious arguments against interracial marriage. But in my experience, those beliefs were never very widespread, and there was never any religious body that I ever heard of, or have heard of since, that ever taught that racial homogeneity is central to the idea of marriage. Nobody ever taught that. But by contrast, all major world religions have always taught that a man-woman union is central and fundamental to marriage. And so, yes, there are a few Christian faiths and a few Jewish groups that have kind of departed from that consensus. But when you do the demographics and you determine, well, what percentage of the population actually belongs to denominations that have accepted same-sex marriage, it's actually a tiny percentage of religious believers. According to my calculations a couple of years ago, it's about 3.8% of the population that belong to denominations that accept same-sex marriage. Yes, there's a larger portion of the population that sometimes doesn't accept the teachings of their own faiths on that subject, but the religions that account for the vast majority of religious believers continue to believe that marriage is fundamentally a man-woman union. And that may be one reason that 3 separate times in his opinion, Justice Kennedy went out of his way to express respect for traditional religious views of marriage, and seemed to offer or seemed to express the hope that same-sex marriage advocates would likewise be respectful of those beliefs. Here's one example. He said on page 4 of his opinion, the view that marriage by its nature is a gender-differentiated union of a man and a woman long has been held and continues to be held in good faith by reasonable and sincere people. Now, he didn't have to write that. That wasn't essential to the outcome that he reached in his opinion. And then later on, a few pages later, he says, many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. Again, an unnecessary expression of respect for the religious views that he that he knew he was running counter to, in his opinion. And then finally, you all are probably aware of this paragraph that comes right at the end of his principal constitutional analysis. He says, finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts same-sex marriage should not be condoned. And then he goes on to say the First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths and to their own deep aspirations to continue the family structure they have long revered. Again, that wasn't essential to his legal analysis or to his conclusions. And by the way, none of the other judges that had ruled one way or another on same-sex marriage in all the litigation leading up to Obergefell, none of the other judges had found any reason to express that kind of respect for religious views. Now, it's true that, as the Chief Justice pointed out in his dissent, that Justice Kennedy's statement here doesn't actually mention religiously motivated conduct. He's talking about speech here. And of course, it would have been nice if Justice Kennedy had talked about the importance of religiously motivated conduct, but for reasons we'll talk about in a few moments, Justice Kennedy has in fact been a pretty good defender of religiously motivated conduct during his career, and so his failure to mention that here I don't think should be taken as any indication that he's just going to rubber stamp attempts by same-sex marriage advocates to override the religious beliefs of people who engage in conduct that's consistent with those beliefs. And so again, of all the opinions that ruled in favor of same-sex marriage, Justice Kennedy's is the most respectful of religion, and not just for the statements that we've read, but also because of the legal theory that it adopted. Now, based on the decisions that had come before, Justice Kennedy, once he decided that he was going to require same-sex marriage as a constitutional matter, he had basically 5 different paths that he could have taken to get there. Okay? One path would be to say that for a state to deny same-sex marriage is based on animus or ill will towards gays and lesbians. And there were a couple of district court decisions, including one in Virginia by Judge Allen, that basically relied on that rationale. Another possible rationale was to say, well, for a state to deny same-sex marriage is just completely irrational. There's no reasonable basis that supports it. That was what a judge who used to be viewed as a conservative judge, Judge Posner in the Seventh Circuit, ruled on behalf of his court. Now, either of those rulings would have been very problematic for religious freedom because they would have suggested that any opposition to same-sex marriage has to be based just on simple bigotry, right? If it's irrational or if it's based on ill will, it's just bigotry, and that obviously would have been a huge battering ram that the other side could use against people of faith. And Justice Kennedy was obviously aware of that. Another approach that Justice Kennedy did not take, in his opinion, was the position that was consistently pressed by the Obama administration and that had been adopted by the Ninth Circuit in a decision by Judge Reinhardt, which is the idea that sexual orientation is a suspect class, or sometimes called a quasi-suspect class. If it's a suspect class, then any regulations or laws that would adversely impact gays and lesbians would be treated essentially as equivalent to laws that would adversely impact people based on race. And Justice Kennedy did not go down that path either. And if you think about it, that kind of a ruling could have had lots of religious freedom ramifications beyond marriage. You know, any time anybody did anything that would adversely affect a member of the LGBT community, that could be viewed as as creating constitutional problems. Another approach that he did not adopt was the idea that denial of same-sex marriage constitutes discrimination on the basis of sex. And one of the concurring opinions in the Ninth Circuit decision had relied on that ground. And his final option, which is the option he chose, was similar to the the option chosen by Judge Lucero in the Kitchen case that I argued and in which Utah's marriage law was at issue. And that was the idea that there is a fundamental right to marriage under the Due Process Clause of the federal Constitution, and that to limit marriage to opposite-sex couples is to effectively deny to gays and lesbians the ability to enjoy that fundamental right. So that was the path that he chose, and although it does create a number of problems that we'll talk about in a few minutes, it's not as bad as one of the other options would have been. So those of us who care about religious liberty can be grateful that as bad as the Obergefell decision was, religious liberty at least dodged some big bullets. But the opinion, unintentionally I think, launched at least 12 religious freedom grenades that are still in the air, and I'll call those the dirty dozen, and they fall into two categories. One set of grenades would threaten individual religious liberty, and another set would threaten institutional religious freedom. And to be fair, in many cases, the Obergefell decision didn't actually create the problem, but it exacerbated a pre-existing problem. So let's talk briefly about threats to individual religious freedom, and I'll run through those quickly since they've been discussed at some length earlier in this conference. One obvious threat is to professional counselors who could well be forced, either by state law or professional standards, to violate their religious beliefs by, for example, assisting a same-sex couple in preparing for marriage. That was a risk that was much lower before Obergefell. Another risk is a risk to other professionals like lawyers or business executives who express or belong to organizations that teach the traditional view of marriage. And the risk there is that, like Brendan Ike of Mozilla, they would be excluded from certain kinds of jobs. And I think many of you are aware that the California Supreme Court recently adopted a rule that said that judges can't be a member of the Boy Scouts of America. One could well imagine rules like that being adopted around the country that preclude judges from serving if they belong to religious or other organizations that teach the traditional view of marriage. Another threat to individual liberty is to school teachers, who could well be forced to violate their religious beliefs by endorsing the idea that a same-sex union is as legitimate a way to form a marriage and family as a man-woman union. Another threat is to parents with children in public schools who could be denied the ability to opt their children out of instruction about marriage and family that contravenes their faith. And once again, that was a problem already to some extent, but now that we have a Supreme Court decision that says same-sex couples have a constitutional right to be married, that makes it easier for school officials to deny parents the ability to opt their children out of programs that would teach that. And of course, we talked yesterday a little bit about the problems faced by clerks and justices of the peace and other public officials who are involved in marriage. Are they going to be required to violate their religious beliefs in the issuance of marriage licenses or even the performance of marriages? And then, of course, there are the threats to wedding service providers, the butcher, the baker, the floral arrangement maker that we've talked about before. The risk there being that they will effectively be forced to participate in a ceremony that violates their religious beliefs. And once again, that was already a problem even in states that don't have same-sex marriage. The famous New Mexico case involving the wedding photographer was in a state that didn't have same-sex marriage. But having a U.S. Supreme Court ruling that says there's a constitutional right to same-sex marriage is just going to make those kinds of problems proliferate, or at least increase the risk of them. Now, to its great credit, Utah earlier in the spring largely handled the first 5 of these problems in the laws that were enacted there. And the last one, that is the wedding service providers, really isn't an issue in Utah at the moment because Utah doesn't have a so-called public accommodations law that would allow somebody to sue someone who denies them photographic services or refuses to bake a wedding cake for them or something like that. But all 6 of these issues are likely to be big problems in many other states for some time to come. Now let's spend a moment talking about potential threats to religious institutions. And here, most of these problems arise not just under state law, but also under federal law, which of course means that Utah's recent law can't fully protect religious institutions that are headquartered here in Utah. Perhaps the best place to start is with the issue that Justice Alito raised during the Obergefell oral argument, and that's discussed in the opinion, and that is the prospect of the federal government or state and local governments revoking the tax-exempt status of institutions that dissent in word or deed from the new orthodoxy that equates same-sex marriage with traditional marriage. During the oral argument, as I think most of you know, the U.S. Solicitor General, Don Barilli, answered Justice Alito's question by saying, "You're right, Justice Alito, I can't deny that that's going to be an issue. That's going to be an issue." And then, of course, the administration's failure to walk back from that after the oral argument, to me, suggests that there are people within the administration who are actively considering doing just that, and revoking the tax-exempt status of at least some religious organizations who continue to adhere to the traditional conception of marriage. Another big risk was also mentioned by Chief Justice Roberts at oral argument, and that is the prospect that that colleges, religious colleges like BYU or Pepperdine or Baylor or Wheaton that offer married student housing could be forced under either state or federal law to offer their married student housing to couples who, in the eyes of the faith, are not in fact married. You know, the problems there could arise not just under state law, and I don't think that's much of a risk in Utah today, but it is more of a risk under federal law. You know, what's to prevent the Department of Education, for example, from issuing a regulation that says, you know, colleges that don't treat same-sex married couples the same way that they treat opposite-sex married couples are no longer going to be available for federal help for their students, like Pell Grants or federally insured student loans. Those sorts of things. Another related risk is the area of licensing and accreditation. For example, accreditation could be denied to a religious college based on its teachings or practices on marriage. And that kind of denial could either be based on state law or a private accrediting body's standards. Or again, it could also conceivably be based on a regulation by the Department of Education that says, you know, we don't want institutions that adhere to the traditional view of marriage to be accredited. Another risk is in the area of government contracts. The decision opens the prospect that religious colleges and religious service organizations will be denied government contracts if they adhere to the traditional view of marriage. For example, a religious college might be denied federal research grants or contracts into things like cartography or vaccine research or things that have nothing whatsoever to do with marriage or sexuality, simply on the ground that they continue to adhere to the traditional view of marriage. And indeed, the Obama administration recently adopted a new sexual orientation regulation that is ambiguous, at least with respect to religious institutions and how they'll be treated. And so in light of Obergefell, we could see those regulations now being extended to marriage policies. Of course, there's a general risk from employment regulation. Can a religious institution of any stripe enforce religious hiring standards with regard to marriage? You know, a stark example might be a religious college that wants to have a married couple teach about dating and marriage. Are they going to be required to hire a same-sex couple to teach that class? Now, in federal law, Title VII, which generally governs employment discrimination for federal law purposes, it has an exception or an exemption that exempts religious institutions from its requirements, but that wouldn't necessarily prevent the current administration, for example, from imposing those kinds of standards as a condition of federal funding. And some state employment laws don't have exemptions of that sort for religious bodies. And so in some states, again, not in Utah, but in some, and I think quite a number of states, state law could well be used to try to force a religious institution to treat as valid for religious purposes a same-sex marriage that has been accepted under state law. And finally is the problem that Justice Scalia mentioned during the Obergefell argument, which is our church is going to have the ability to marry their members and have those marriages recognized by the state even if they refuse to marry same-sex couples. That is, will churches be allowed to discriminate against same-sex couples in their marriage practices and still have those marriages recognized by the state? Again, I don't think that's a problem in Utah, but I suspect we will see that issue arise in a number of states around the country before too long. Well, what can be done to dodge these grenades that I've described? And I have three general suggestions besides being civil and respectful in the way we approach these issues. Number one is I think we need to calmly and consistently explain why each of these issues in fact involves genuine religious liberty concerns. Now, you all have heard from the LGBT community that they generally respond to those concerns by saying, well, they don't implicate genuine religious liberty concerns, and when pressed, they rely on a Supreme Court decision from 1990, Smith versus Employment Division, that cut back on the Supreme Court's enforcement of the Free Exercise Clause of the First Amendment, and it said, contrary to what had been the law previously, it said that as long as a law is neutral and generally applicable, even if it has incidental effects on religion, it's not subject to any particular heightened scrutiny under the First Amendment. And so as a result of that decision, it has become much, much more difficult to win claims under the Free Exercise Clause of the First Amendment. And so when the LGBT people say, no, these don't involve genuine religious liberty issues, what they really mean is, we think you would lose that claim under Smith. Well, think about that logic, though, and how it would apply to things that the LGBT community is seeking, right? They would never accept the idea that the concept of freedom from discrimination should be limited to what has already been held to be unlawful discrimination under the Constitution, right? If they, I mean, their conception of the value of anti-discrimination extends well beyond what the Constitution itself protects or what court decisions under the Constitution have been held to protect. And so in the same way, the concept and the value of religious liberty isn't limited to what the Supreme Court has said is narrowly protected by the Free Exercise Clause of the First Amendment. And I think some of the leaders of the church have recently made that very clear, that as members of the LDS Church, we should not adopt a conception of religious liberty that's limited to just what the Supreme Court says the First Amendment protects. Now, my second suggestion is to get all of the protective legislation that we can at both the state and the federal level. And some people might ask, well, why can't existing law adequately address these issues? I've explained why the Free Exercise Clause will probably not be enough to deal with most of these issues. But why, if a state has a Religious Freedom Restoration Act, why wouldn't that be enough? Why wouldn't the federal Religious Freedom Restoration Act be enough? And in a lot of cases, those authorities and state constitutions will be very, very helpful. But the problem is that none of those authorities focuses specifically on the conflict between same-sex marriage and religious freedom, and therefore it can cost millions of dollars in legal fees to win a decision that says, yeah, that particular bit of religious conduct is protected. Is that fair, Alexander? Is it uncommon to have to spend $1 million or more in legal fees to?
I'm just surprised you're complaining about that.
Well, I think it is a tragedy, actually. I mean, there's plenty of work for lawyers like me and Alexander without having to impose those kinds of enormous costs on clients. But anyway, that's a very good reason to seek targeted protections for religious freedom in the face of same-sex marriage. And at the end of the day, on a lot of these issues, we don't really know how, what the answer is going to be until it's fully litigated. And so that's one reason the effort in Utah, I think, was so valuable, and I hope it'll be replicated in a lot of other states around the country. It's also why a proposed statute that was recently introduced by Senator Lee and Representative Labrador from Idaho, I think could be very valuable. It's called the First Amendment Defense Act. How many of you have heard of that? It's something that's worth paying attention to. It would, I think, protect religious institutions and people of faith against the most serious kinds of retaliation that might be asserted by a federal agency. And so it would go a long way towards dealing with these institutional problems that we discussed earlier that would arise in significant part from federal law. Similar laws, similar laws could also be adopted at the state level, and I think that would be very useful. And even governors have a lot of authority over the religious freedom clashes that their agencies can create. And I think Governor Jindal of Louisiana set a great example a couple of weeks ago by issuing an executive order that, at least to the extent of his authority as governor, prevents state agencies from retaliating against people based on their religious beliefs or taking other actions that are going to intrude unnecessarily into the religious beliefs of Louisiana citizens. My third general suggestion, paradoxically perhaps, is don't be afraid to go back to the Supreme Court on a religious liberty issue. The Supreme Court's record of protecting private religiously motivated conduct is actually pretty good. And here's we're not going to have time to go through these obviously, but here's a list of cases from 1987 to 2005, which were decided by the Rehnquist Court, and that's before Chief Justice Roberts became Chief Justice. But there were 11 cases during the Rehnquist Court that in one way or another involved protection for religiously motivated conduct, and in 8 of those 11 cases, the Rehnquist Court ruled that yes, that religiously motivated conduct was protected. One of those, one of the big losses was the Smith case from 1990. But there were only 2 other cases in which the position seeking to protect private religiously motivated religious conduct were rejected. And here's a list of similar cases decided by the Roberts Court, and as you'll see, in only 1 of those 6 cases has the court rejected the idea that the private religiously motivated conduct at issue there should be protected. And so if you calculate the percentages, which I learned the other day PowerPoint actually allows you to do, the overall results from this entire 28-year period from 1987 to 2015 is that in 76% of those cases the Supreme Court held that yes, the religious conduct at issue was protected. The percentage was a little lower for the Rehnquist Court at 73%, and quite a bit higher for the Roberts Court at 83%. Now you might ask, well, how do the individual justices treat these issues? And PowerPoint helped me calculate those percentages too. But before I show you the results for the individual justices, which of the, and here's a picture of the Roberts Court as it exists today, and 5 of the justices there were holdovers from the Rehnquist Court. Everybody except the Chief Chief Justice Roberts, Justice Alito, Justice Kagan, and Justice Sotomayor. All the other 5 were holdovers from the Rehnquist court. Anybody want to take a guess as to which of those 5 justices is the most protective of religiously motivated conduct? Well, Alito wasn't there yet. Clarence Thomas? Kennedy? Okay. Anybody want to take a guess as to who is the least protective of those 5? Scalia? All right, here are the results. Scalia, in fact, is the most protective of those 5 justices at 88%. Thomas is second. Justice Ginsburg is at the bottom at 42%. And as you can see, Justice Kennedy is very high, and he votes in favor of protecting religiously motivated conduct about twice as often as Justice Ginsburg does. And as you can see, we've got a couple of newer justices, Roberts and Alito, who have voted in favor of protecting religiously motivated conduct 100% of the time in all the cases that they've decided. And even the more recent Obama appointees have voted in favor of that result 60% of the time. So it's a pretty good Supreme Court for dealing with religious freedom issues. And in fact, I would argue, although I haven't done this detailed analysis for every justice in history, but my guess is that our current Supreme Court is probably the most protective of religiously motivated conduct in our history. So it's a good time to be pitching religious liberty cases in their direction, especially when what we're asking them to do is to uphold a statute, a democratically enacted statute that protects religious freedom. They almost always uphold those. The greater difficulty arises when you show up without a statute that you can rely on, and you have to say, we want you to rule in our favor solely on the basis of the Constitution. That's a much more difficult argument to make there. So the bottom line is, and to add yet another metaphor, Obergefell has opened a religious freedom can of worms. Justice Kennedy seemed to recognize that risk, and as we've discussed, he tried to convey a certain level of respect for traditional religious views on marriage, but still, it'll be several years before we know where all the worms end up. And where they end up will depend in large part on what we do about it in our advocacy to legislators, governors, government agencies, courts, and of course to the public. In all of which, I hope we'll all continue to heed Elder Oakes' twin injunctions to be civil, but also to keep standing up for our values. Thank you.
Well, that was terrific. It's a privilege to be here this morning. I want to begin by thanking Bob for the invitation. I appreciate this opportunity, and I'm grateful for the work that you and of course Cole Durham do, and all the others who have worked to put this conference together. And this is an important gathering, and in the years to come it's going to become even more important. It's going to become important for people to get together and to talk about these subjects and to debate and to seek understanding and then try to figure out how best to proceed. So I'm grateful to be a part of this morning. And I'm grateful for Jean. Thank you, Jean, for your presentation of the Supreme Court's recent same-sex marriage decision and its sobering implications. But more importantly, thank you for the sacrifices that you've made on behalf of traditional marriage and the cause of religious liberty. Gene downplays those sacrifices. They're actually quite real, and he's a tremendous example to all of us as one who has and is standing as a witness for the things that he believes. We're all going to have to do a lot more of that in the months and years to come. How many of you, by a show of hands, are not attorneys? Oh wow, that's wonderful. How many of you attorneys kind of wish you weren't attorneys? No, just kidding. I asked that question because I want to spend time talking as much to non-lawyers as to the lawyers among us, because, as this conference reminds us, it is high time that the issue of religious liberty cease to be primarily a legal issue to be debated by lawyers and law professors and judges. Religious liberty is as much about our culture and how we live together as free and equal citizens as it is about legal theories and lawsuits. And how we live together is not ultimately for lawyers, law professors, and judges to decide. That is something that all of us, we the people, are going to have to figure out for ourselves. The question this panel has been asked to address is, what will be the effect on religious liberty of the Supreme Court's gay marriage decision? And I'm glad we've sort of come to a consensus that it's pronounced Obergefell, because frankly I had no idea how to pronounce the thing. And I have an absolutely certain answer for you. The answer is, it depends. It depends on how our culture and how our society react to the decision, and how in turn the law reacts to those cultural and social changes that will be unleashed by this decision. Now let me venture for a moment into judicial philosophy, or at least my version of judicial philosophy. I always wanted to be a law professor, so you kind of look like a law school class, and I'm going to pretend for a moment that I am. To use a really abused word, our culture and the law are in a symbiotic relationship with each other. In fact, if there's one thing that has become abundantly clear from the Supreme Court's same-sex marriage decision, it is that when it really counts, constitutional law is as much about culture as it is about the Constitution. Many of us have this image of our judicial system where judges sit in their dusty chambers dispassionately scrutinizing legal texts in light of objective tradition and history and legal precedent. And then after much study and searching, they come to carefully reasoned conclusions that allow them, in the words of the great Chief Justice John Marshall in Marbury versus Madison, to say what the law is. They have this eureka moment, and there it is, the law appears, and they declare it to the people. And that may well be accurate to an extent, in many cases that judges tend not to care very much about personally, such as fights between powerful corporations over intellectual property rights and contractual rights, or tax disputes, or any number of other legal areas that judges routinely deal with. But when it comes to novel issues of constitutional rights, including matters of religious liberty, there's often much more going on than just judging. Constitutional law in these kinds of cases is often, not always, but often, a lagging indicator of elite opinion, elite cultural opinion, tempered by the broader American culture. In other words, over time, the legal and cultural elite come to a conclusion about what the Constitution requires in such matters, and then judges, who are part of that legal and cultural elite, tend to adopt those views, provided that they do not lead to conclusions that are too inconsistent with American culture and expectations. Hence, although much of the legal and cultural elite had concluded well over a decade ago that same-sex marriage should be a constitutional right, it was not until this year, when at least half of the American people, according to some polls, seemed to support gay marriage, that the majority of the Supreme Court justices felt free enough to issue a decision finding a fundamental right to same-sex marriage. Again, in these sensitive constitutional areas, culture often drives constitutional law as much as the words of the Constitution and legal precedent drive constitutional law. And conversely, it is also true that constitutional law drives culture. They have a relationship that goes back and forth. The law itself is a teacher. There is a tendency, for example, for people to believe that what the Supreme Court says the Constitution requires is in fact what is right and good for society, and that any opposition to that is by nature wrong. Thus, culture affects law, and law in turn affects culture. Okay, that's my little piece on being a law professor. I'm not sure how well I did. But here's the question. What on earth does this have to do with the religious liberty in the aftermath of the Supreme Court's same-sex marriage decision? As it turns out, it has a lot to do with it. I believe there are two very different paths that our culture, and hence our law, can go down when it comes to the religious liberty of those who sincerely believe as a matter of faith and faith-filled reason that marriage is and should remain between a man and a woman. These are two kind of models, I think. And these are kind of rough approximations. No model is exactly right, but something to think about, because we've had experience in some of these controversial areas before. The first path or model would be analogous to what happened after Brown v. Board of Education and Loving against Virginia. It is the path that we as a nation took when it comes to race and racism. As you know, after a long struggle that included the Civil War, 3 amendments to the United States Constitution, and heroic efforts by thousands of civil rights activists and ordinary citizens, in 1954, the United States Supreme Court unanimously held in Brown v. Board of Education that state-sponsored racial segregation violates the Equal Protection Clause of the 14th Amendment. This ruling paved the way, of course, for racial integration and the dismantling of the Southern apartheid regime. And then, as almost a capstone to a series of civil rights decisions, in 1967, in the case of Loving against Virginia, the Supreme Court again held unanimously that laws against interracial marriage also violated the 14th Amendment. As vitally important as these cases and these Supreme Court decisions were legally, they had a profound effect culturally. Together with laws passed by Congress, they of course made racist actions by government unlawful. But far more profoundly, they also contributed to a culture that made racist speech and even racist ideas by individuals socially and culturally taboo. Yes, the First Amendment still protects the right of racists to spout their hatred from the street corner, but if you do so, you will be a social outcast. In most communities, you are likely to be terminated from your employment by one means or another, if you can find a job in the first place, and you certainly won't have a legal career to speak of, and you can forget about playing, in most communities at least, any active role in the political or social life of your community. Now that, of course, is all well and good. Racism was and is a scourge, and we properly attach very severe social consequences to those who engage in it. My point is simply that there is very little real freedom or social space in which to be a racist. We've essentially said, we don't want that among us, and we will exclude it, marginalize it, and keep it out of our midst. If the Supreme Court same-sex marriage decision results in support for traditional marriage being equated culturally and legally with racism, then as a practical matter, religious liberty will be severely restricted. Under that model, government itself will come to have powerful justifications for suppressing and marginalizing religious beliefs, speech, and especially actions that challenge the new right to same-sex marriage. Schools will be expected to instruct children in the new marriage ideology and to suppress speech and beliefs that run contrary to it, just as schools do now when it comes to racist speech and viewpoints. The expression of pro-traditional marriage viewpoints within the workplace will be seen as harassment that cannot be tolerated, even as pro-gay marriage viewpoints are openly discussed. There will certainly be no right to avoid providing services to activities related to same-sex marriage, such as photography and as Gene said, the butcher, baker, and candlestick maker. And institutions, including churches and religious schools and universities, that have sexual teachings and standards rooted in traditional marriage can expect eventually to have their tax-exempt status challenged. Indeed, if support for traditional marriage is equated by our society and culture to racism, then really every negative outcome that Gene just warned about and worse will become a very real risk. But there is another path or model that things might go. In 1972, in Roe v. Wade, a divided Supreme Court remove the issue of abortion from the democratic process, declaring that abortion is, as the Supreme Court declared with the same-sex marriage case, a fundamental right during the first 2 trimesters of pregnancy. What followed could have been something like the aftermath of the Brown and Loving decisions, where anyone who questioned the right to abortion would be driven out of polite society and marginalized socially and legally. There were certainly cultural forces in place to push that kind of an outcome, but that didn't happen. Today, it is entirely possible for a strong pro-lifer to be open and frank about his or her beliefs in public, in the workplace, at school, and in the various other areas of life. Now, of course, there may be severe criticism in some quarters and even angry and passionate debates, but one does not become a social pariah for conscientiously stating positions against abortion. Indeed, various laws and court decisions protect beliefs, speech, and even actions that oppose abortion. If in the aftermath of the same-sex marriage decision our nation follows something like the example set in the aftermath of Roe v. Wade, then religious liberty will survive and in fact probably do quite well. There will be hard times, to be sure, but eventually there will be accommodations for those who honestly dissent from the new gay marriage orthodoxy. So for me, a critical question at this juncture is, how is it that opposition to abortion was able to secure a place of respectability in our culture and law? How did we get to the place where you could be a pro-lifer and still have a career and still be open, still express your views, and not become something of a social outcast? Now, the answer to this question is no doubt complex, and as Gene has pointed out, the language of the Supreme Court in these kinds of decisions does make a difference, what theory the Supreme Court used, and in the case of Obergefell, the Supreme Court used a fundamental rights theory, which is very similar to the one used in Roe v. Wade. That is a potentially a good sign. But assuredly, one of the key reasons is that religious and other pro-life voices, including, of course, pro-life Catholics and evangelicals who really took a leadership role in this area, decided that they would not, indeed could not, remain silent. They spoke up. They refused to be intimidated. They organized. They insisted on their rights of free speech. And they learned to make their case with reason, civility, and even love. To be sure, there were extremists within their ranks, those willing to disregard the law and even commit terrible crimes. They had to be denounced and removed. There were missteps. There were mistakes. There was retrenching. But eventually the pro-life movement found its voice and succeeded in convincing about half of the American people of the rightness of their beliefs. Of course, not much has changed legally. The Supreme Court still insists that abortion on demand is a fundamental constitutional right, so Roe v. Wade has not been overturned. Nevertheless, the fact remains that those opposed to abortion can still be full and equal citizens, participating in all walks of life, from school teacher to business person to lawyer to President of the United States. That is very significant. The right to be a pro-lifer has very much been preserved. In my view, the effect of the Supreme Court same-sex marriage decision on religious liberty will depend to a very great extent on people like you and me. If supporters of traditional marriage retreat, if they are intimidated into silence, if they give up trying to find the right words and arguments to defend their beliefs, if they do not stand as witnesses and living examples of the goodness of their beliefs, and if people of goodwill do not at least stand up for the rights of others to dissent in good faith, and yet still be numbered among us as our fellow citizens, neighbors, colleagues, and friends, then the Supreme Court's gay marriage decision will indeed become a disaster for religious liberty. But if those who support traditional marriage are indeed examples of what is highest and best about their beliefs, if they, like the pro-lifers, refuse to be silenced, if they find ways to explain and persuade with reason as well as kindness and meekness and love, and if they cheerfully but resolutely endure the indignities that will indeed be visited upon them without bitterness, asking only for toleration, understanding, and their basic rights as Americans, then I believe that ultimately the great goodness and decency of the American people will rise up, and our culture and law will carve out and protect enough spaces so that people of faith and their institutions who maintain traditional beliefs about marriage, family, and sexuality can participate fully in all aspects of American life. Now, that will not happen all at once. Those of us who hold such beliefs are assuredly in for some difficult and uncertain times. Sacrifices are going to have to be made. Carefully chosen lawsuits will have to be filed. We may even lose some friends on Facebook, or maybe even some real friends. But I am hopeful that in the end, if we stand firm, both our culture and the law will accord those who believe in traditional marriage the respect and freedom they deserve. Thank you.
I don't know about you guys, but I want to take a class with Alexander. How many people want to take a class? Yeah, right? See? Okay. And the nicest thing as a law professor, and I say this with some chagrin, I'm afraid, is that Alexander should get an A+ as a law professor, because I heard more about the law and the Constitution from him than I hear from almost any law professor in most elite law schools, which is a tragedy. So, anyway, A+. Yeah, hear, hear. Thank you. So I'm going to take a different tact. I exhausted, I apologize to you yesterday, all of what I had to say about religious freedom, so I want to go in a different direction and talk about some of the apocalyptic language that we've heard and some of the threats that I think are emerging and why we want to resist them. So I'm going to pick Ted Cruz, just because he's an obvious candidate. And he said, after the marriage decision, "It's my hope that the marriage decision serves as a spark to start a fire that becomes a raging inferno." Now, I have no idea what that means. I actually have no idea what that means. But what it does tell us is that bubbling up with all of us, many, many people across the country, is a deep frustration. And I think in that deep frustration, at least two reactions for me are likely to get traction, and I think are likely to be dangerous to the cause of religious freedom ultimately, and possibly to marriage as an institution itself. So one I touched on yesterday, I'll go back to it for a second. It was what I called the canary in the mine, and this is the marriage and the licensure clerk, because they will be implicated in every state in America. As we said yesterday in a long discussion, many states don't have public accommodation laws right now based on sexual orientation, so some of these collisions won't arise. Some of the ones that Jean described won't ever happen, at least until those public accommodation laws come online. But you will have marriage and licensure clerks implicated in every state in America because the state has the monopoly power over marriage. Now, yesterday I mentioned that offices in Alabama had shut down literally the entire marriage function to everybody. And this apparently also happened in Kentucky, I learned over the night, precipitating lawsuits by the ACLU. Didn't take the ACLU long, did it? Now, I think shutting down these offices entirely is the worst possible way to proceed, as I said yesterday. Maybe made a terrible analogy to Orville Faubus, but basically, at the end of the day, I see this as an apparatus of the state, defying a Supreme Court order that represents the law of the land. By shutting down a function entirely to exclude gays, they're denying it to everyone. And for me, that violates the separation of powers and the rule of law. You might take a different view of that, but I think it's the wrong way to go. Now, we've seen other approaches in the last year. So, for example, North Carolina did something that's clunkier than what Utah did. I think Utah got it right. I'll tell you why again at the minute. But what North Carolina did, in an effort to shield objecting employees from collisions over same-sex marriage, it basically instituted a procedure where magistrates and marriage registrars could recuse themselves for solemnizing or registering a marriage, and that recusal lasts 6 months. Now, this was actually deeply contested. 5 years ago, this would have been uncontroversial, but the goalposts have moved as same-sex marriage has been recognized. I think we had a lot of discussion about that yesterday. But this became law only after overriding the governor's veto in North Carolina, and it was a nail-biter, not in the Senate, but in the House. Now, I think the real problem is that when religious objectors pull down on this accommodation in North Carolina law, they can do it the very first time a gay couple presents. And what that means is that you are going to have a point of service refusal. In other words, a gay couple who is there seeking a license to marry, supposedly the happiest day of our life, are going to be told by somebody, that that person has a moral objection to their marriage. And it's going to feel like a moral objection to them. And not only do I think that that's uncool, that we don't, as taxpayers, receiving a service from the state, need to be told by a government employee of the state what they think about our personal marriages, right? But the other problem is going to be that you have to know that that state office, right, or that state is going to have hell to pay, right? We've seen what happened in Indiana. We've seen what happened in Arizona. This is not the right way to go. Now, North Carolina could have avoided that kind of offense to its citizens. And I think it can actually still do this by policy. It could have required that officials recuse themselves ex ante, and before the fact, in writing, in order to staff around the objector so that the objector never actually comes in contact with the public. So why would that be better? That would be better because imagine a couple, Steve and Adam, present at the marriage office, which has 3 officials. Let's call them Faith, Hope, and Charity. And only Faith is going to have a religious objection. Now, I want to tell you, my big project in Utah, the single reason that I spent time here, was so that Faith does not get dropped out of the boat, right? Faith gets protected. But in this situation, we do not want Faith at the front desk saying to Steve and Adam, oh my God, let me go get Hope or Charity. Instead, we want Hope or Charity doing the intake. And Faith perfectly, reasonably, legitimately can be doing other functions of the office. For example, in North Carolina, she can issue subpoenas or take affidavits or do any other thing that that office does, but she should not be at the front desk if she has an objection. Now notice that Faith is not receiving a pass from doing her job. She performs other functions of the office, and neither is the office failing to do a service that it owes to its citizens. It does it. It fulfills it with Hope or Charity. Now note what also does not happen, and this will be the threat to religious freedom if it does happen. Steve and Adam are never asked to wait longer. They're never asked to step into another line. They never even know that Faith has a private view about their marriage. So dignitary harms evaporate when we make accommodations invisible to the public. Now, we can't make accommodations invisible to the public in every context, but at least when it is an office of the state, I think it is very important to try to achieve that goal. Now, why do I think that Utah improves even on North Carolina's clunkier approach? Because they did not have the invisibility part that I just described. They just had recusal, step away. And I think Utah improves on that, as I said yesterday, by bypassing the objector entirely, essentially outsourcing that function of solemnization to a willing, authorized celebrant in the community, which could be a judge, a religious official, or other people. So Utah both guaranteed access to marriage to everyone on exactly the same basis, and it avoided dignitary harms to our lesbian and gay neighbors. So that's problem one. There are better and worse ways to deal with that. We've got to resist doing it in awful, clunky ways. Second bigger problem, and apologies here because this is a new paper that I'm writing, which of course means I don't completely understand what I'm saying. But don't fault me for that. It's only been 10 days since the decision, so I haven't had a lot of time. But basically, we have heard a constant refrain. How many people have heard this? Let's take the government out of marriage. How many people have heard that in the last few weeks, right? Even before. Now, I don't know what that means either, actually. I'm not sure the people who have introduced legislation knows what that means, but I'm going to describe some of it to you, and then I'm going to tell you why we should resist it. In essence, so let me just tell you where some of the genesis of this was. First Things, which is a Catholic intellectual magazine, actually published a pledge which now has been signed by 656 religious figures to, quote, separate civil marriage from Christian marriage. Now, for them, this seems to mean that they should, quote, no longer serve as agents of the state in marriage, no longer sign government-provided marriage certificates. Instead, they're going to ask their own parishioners to seek civil marriage separately from their church-related vows and blessings. So they are, in essence, taking what in our system has been a single step, that the religious ceremony accomplished the religious marriage and the civil marriage in a single step. That's how intimately bound up they've been in our system since the colonial times, okay? They want to take those two steps and divide them into two. Now, the motivation for the pledge, I don't have any problem with, and Cole started us off with it early this morning when he talked about complicity. In essence, these folks do not want to, quote, falsify God's word by participating in civil marriages that they see as being fundamentally redefined. And they believe that to continue to do this, to continue with church practices that intertwine government marriage with civil marriage will implicate the church, they say, in a false definition of marriage. But the basic tension here is that in our system, as I said, religious and civil marriage has always been bound up in this way, a single collapsed step. Now, it's true, you can get the civil marriage part without a religious marriage, right? But you cannot in America, in any state, get a religious marriage without the civil part. On this side, they have to be bound up. Now, that's actually, it's a crime, by the way, in every state in America. And that's actually a good thing, that we collapse religious marriage with civil marriage, because we want religious marriage to have civil effects. Without them, we will have stranded religious adherents in the position of mere cohabitants under the law, which means that they have crappy remedies, right? They're not going to get spousal maintenance. They're not going to have the division of property, that type of thing. And who loses in a scheme like that? It'll be the traditionally vulnerable partner, or especially dependents, women, and children. Now, children will get child support. These women will not have property division. They will not have spousal maintenance available to them. And the children will lose because their mothers, if they have custody, will experience severe financial strain. Ironically, this idea from this Christian source would put these women in the same position as women who are in the Sharia courts in Great Britain right now. Because what has happened in Great Britain is that these women have marriages that are off the grid. In other words, they have a religious marriage and no civil effect. And that means that the Sharia courts are applying religious norms to these women in Great Britain that wildly depart from what civil law in Great Britain would provide, like maintenance, property division, and those types of things. So it's deeply ironic that some people reacting to same-sex marriage are actually trying to move women potentially in this awful, awful place in ways that I think are really unfortunate. Now, you could say, Wilson, whatever, we'll just give some education to these women and they will know to go do the second step. So it's solvable. And we do that in other countries, apparently, although I'm still educating myself about that. I think, though, that that's still fraught with risk, at least in the near term, because there will be weaker earning people who don't know to do that, right? So in the event of divorce or death, right, it's not just divorce, they may be left unprotected by the law, and that would be unfortunate. But notice what the First Things Pledge is trying to do here. It would foist what it sees as a government duty onto the government and have religion withdraw from the world in an important aspect. So kind of become an island. Now, in the 10 days after the decision, we have state legislatures around the country introducing measures also to sever the tie between religious and civil marriage. But they would foist the marriage function away from the government onto religion, ironically going exactly in the opposite direction. So Texas State Representative David Simpson has asked the Texas governor to call a special session to, quote, divorce marriage from government. He says that government has basically redefined it at the federal level, so let's just get out of the marriage business. Now, for him, this would take the shape of changing the law so that clergy members would issue marriage licenses. The state would have nothing to do with it. Other Texas legislators have said that this is a knee-jerk reaction. We see in Michigan, though, Representative Todd Corser, weeks in advance of the same-sex marriage decision, introducing 3 bills. 2 are relevant here. But both of these would fundamentally change the nature of the state to civil marriage. One would permit religious marriage only, ditching civil solemnization entirely. So if you want to be married, you have to be religiously married, that law would say, or that bill would say. I think that's sort of interesting as a problem too, because there'll be people in Michigan, I would assume, that reject religious marriage. So that would cut them out of marriage, and that seems to me a non-starter. The second bill would preserve religious ceremonies but eliminate the state license in favor of a marriage certificate signed by the clergy. So if you had a religious marriage, you just have this certificate. On the civil side, there would be no license and no solemnization, only the actual institution of what he calls common law marriage, which, the whole arc of common law marriage in the United States has been to get rid of it. And this guy is bringing it back. And there would be no solemnization function at all. So let me tell you where my problems with this are, and then I'll wind up. Just like 1 minute, okay? So whatever form this unwinding of civil and religious marriage takes, I think we should be loath to embrace it. And for basically lowercase c conservative reasons. I think we cannot predict well what the outcome of this unwinding will be. So civil marriage benefits from religious marriage, I think, in many ways. You can think of civil marriage as having free-rided on religious marriage, in the sense that religious marriage has norms of permanence and fidelity and monogamy and faithfulness and sexual exclusivity, and they get put into our marriage culture as part of civil marriage, okay? And we can't peel one part away, religious marriage, without adjusting or changing the norms with respect to the rest. At least that's my fear. It would be not unlike that pitcher of water. If I tried to pour over that pitcher of water and leave the ice, it's an impossible task, right? And I think norms work that way. In other words, we can't just peel off the one part that we like or don't like and leave the rest. So in my view, this risks a deep cleaving into marriage, into the nature of marriage. And that would be unfortunate, because I think, and we know empirically, marriage protects the adults and it protects the children in it, right? But we don't really know why. We don't know if it's the exit rules, i.e., what a hassle it is to divorce and the fact that you have to divide property and all of these things, right? Or if it's those religious norms, right? So the chances that we're able to make this cleave in a way that doesn't do great damage both to religious marriages and civil marriages, I think, are small. And in any event, I'll just say we've played with marriage a lot. And same-sex marriage may not be nearly so important as what we did when we embraced no-fault divorce. And we thought this was a grand project, right? Ronald Reagan signed this into law in California, if you'll remember, all because adults needed to have the freedom to have, new sexual partners and fulfill their lives and move on with themselves and all these great reasons. And at the end of the day, it eroded our marriage culture, and it had lots and lots of repercussions for children that I think we could never have imagined. So we don't want quickly to cleave deeply into marriage as a way to solve and to make ourselves feel better about a great loss on marriage for many people, right? It's a dangerous thing to do, and we should not do it.
Okay, we have some time for questions. We have 2 microphones, and we want to take some questions right away. Yes, right here in the center. Right there. Yeah.
Alexander, you very persuasively made the case for us making the case for separating and the 2 models that you gave us, that we make the case for following, seeing Obergefell in the history of the sexual revolution and substantive due process decisions by the court or other ways of expanding liberty and sexual liberties that many of us propose, contrasting that with that which is generally accepted by society, which most of us, probably all of us, accept in civil rights legislation. Gene, you brought up in your presentation that the Roberts Court, I believe it was maybe 5, 6 decisions, all of them but one, finding on the rights of for religiously motivated conduct. The one exception to that, of course, was Christian Legal Society. By my count, the only case that dealt with sexual orientation in the group that you mentioned. At the heart of that case is a distinction between behavior and conduct. That's also at the heart of what Alexander raised with respect to civil rights and the comparison between civil rights and abortion. One, on the one hand, orientation or attractions being seen in a characteristic. The other, sexual behavior, being conduct growing out of the sexual revolution. Right now we have a 5-4 majority that have said that sexual behavior and the conduct cannot be separated. How do we make the case, and making the cultural case for, and I'm being a little bit brief when I say cannot be separated. I should say that a distinction, a discrimination based on the conduct would be equated with a discrimination based on the orientation. I'll probably be brief in my description of Christian Legal Society. But getting at this fundamental issue of distinctions between attraction and distinctions between behavior and conduct, how do we make the case in a religiously declining society for separating those two out so that religious institutions and religious individuals can continue to make distinctions based on behavior that they oppose without offending or being accused of discriminating against orientation, which they can, consistent with their faith, respect.
Okay. What's it? You want to take it? Yeah, go ahead.
Mike, I think the short answer to your question is to do a lot more of what you did so effectively in the amicus brief that you filed in Obergefell, which was essentially I don't know how many of you saw that, but it was a collection of testimonials from a number of gay men who married women and are happily raising families together. Many of them have their stories on the Voices of Hope website, and I think that's, I think that's the best thing that we can do to continue to draw that distinction between attraction and conduct, is to be able to point to real-life examples of people who admit to having strong same-sex attraction but who have made a different choice than what the LGBT movement wants us to believe is the only acceptable choice.
Could I respond a little bit to that as well?
Sure.
That's going to be a hard project, right? I mean, that's going to be difficult, and we're going to need to do some of that. But I think even more importantly, we need to show that beliefs about sexuality are profoundly important to us and our lives, and to our own dignity and our own identities. And when we establish that, then other people, good people, have to respond. They have to say something. They have to react to that. This is profoundly important to me, your move. What is your move going to be? Are you going to suppress me? Are you going to force me to do something I don't want to do? Or are you going to respect me? And we need to find ways to articulate why it is that these things are so profoundly important to us, how they relate to our identities, to our dignity, to our individual lives. And when that happens, and when we find those words and those ways of being persuasive, American people are generally tolerant people. Americans don't like to force people to do things that that hurt, that they go against who and what they are. And I think we'll find a great deal of empathy then in the American people for not only our beliefs, but for the institutions that allow those beliefs to flourish. So sometimes we may have to be drawn into very narrow arguments, like the desire conduct distinction. But I think very often we're going to have to do a lot more of explaining why particular things are important to us and why they're profoundly related to who and what we are and how we live our lives.
Thank you. We have a question over here, if you could be brief with your question.
Yeah, we reviewed Justice Kennedy's statements in Obergefell stating that people could have good faith religious beliefs to justify their opposition to same-sex marriage. I've not read United States versus Windsor, but I thought that in that case, Justice Kennedy actually said only animus could explain someone who opposes same-sex marriage. Do I misunderstand Windsor? Is there a contradiction or not?
Gene?
I don't think there's a contradiction. Windsor did conclude that based on the legislative history of the Defense of Marriage Act, he felt like the only explanation for what Congress did there was animus. Now, I think he was wrong about that, but you know, as we saw in Obergefell, that reasoning, in his view, did not carry over to the democratic process that had caused so many states to enact protections for traditional marriage.
Thank you. Let's see. We have a question right here. If you could be brief, thanks.
You mentioned the Smith case, and I reread that after Obergefell, and Justice Scalia mentioned in that case that when you combine the free exercise clause with some other constitutional provision, then you get back the heightened scrutiny. And I'm wondering what your thoughts are on using the Kennedy approach, that dignity and the other areas that he said are now protected by the substantive due process clause cannot be used in combination with the free exercise clause to argue in favor of the religious liberty that we were talking about yesterday, going to the very core of our identity and that type of a thing. I'm wondering what your thoughts are about that.
Yeah, that's a creative suggestion. I don't know that we'd get Justice Scalia to buy that, but it's a creative suggestion that deserves some exploration in a particular case where it might be useful.
Yeah, it's not clear the Supreme Court was really serious about this hybrid rights notion. You know, they may have been or they may not have been, but the tool is still in there. And so as outrages arise, as bad facts, or in our case perhaps good facts, arise, you may be able to combine and mix and match some of these theories in order to get around some of the roadblocks that Smith creates. Kennedy, of course, got around a ton of roadblocks to get to where you know, he got in the Obergefell decision. I mean, he just completely swept away you know, entire lines of precedent on substantive due process to go where he eventually went. And you know, that can occur in other contexts as well, in the religious liberty context, if you get the right case.
Let's see. Let's go with Don here, and Dino. Don, go ahead.
Thanks. Just I'd like to have you comment on a quote from Elder Dallin H. Oaks on the occasion of his appointment to the Utah Supreme Court. He was asked his opinions about the Reynolds decision of decades before, but it was relevant to him because two of his ancestors had spent considerable time in federal prisons as a result of that case. Now he was coming to the Utah Supreme Court, and a reporter from the Deseret News asked him his views now, if he would reflect on that case and its relationship to religious freedom. This is a quote that we don't hear very often, and I, for that reason, would like your comments on it. I am of two minds on whether the Reynolds case, on the one hand, it was a terribly prejudiced ruling. On the other hand, it correctly put limits on how far religious practice could be permitted to go. And there have to be some limits to religious practice, even though it's protected by the Constitution. The Reynolds case was a first cut at putting limits on religious freedom, and those limits had to be placed. So I appreciate your reflections on that, whether there's any relevance today.
Raman, do you want to say anything?
Oh, yeah. So I think, you know, when we have a contest between individuals in the state, I'm going to step up for religious freedom as much as I possibly can. right? With consideration for access. But the one place where I think we should not want to do that is in the debate about giving deference to religious norms in the family, because in my view, that's a zero-sum game. So if you say, for example, that you would give deference to certain Islamic notions of how property should be held or split in the family, that actually means that these women lose, right? So in one of the 7 schools of Islam, for example, you pay alimony for 3 months. I don't know if any of you all have ever paid alimony, but every person I've ever met that paid alimony is like, woo, 3 months and I'm out? That's for me, right? Without respect to whether these women would be in fact cared for by their fathers or their sons in that system. And it turns out that many of these women in fact are left adrift in that system because their religious norms are for some reason just flee in the face of a social safety net, right? And these people get dropped on the social safety net. Likewise with property, likewise with custody, right? So women would lose custody of their adolescent children in favor of the father without respect to best interests of the child. So there are times when we should not tolerate religious outcomes or claims for religious freedom when they are going to have when they're going to represent sharp breaks from what the civil state has said we do to protect dependents.
Thank you. We have time for one more question. Dino?
Hello.
I think it's working.
My question is a follow-up, actually, kind of to that. In your argument against separating civil marriages from religious marriages, you speak about exit rights and divorce. But if you're speaking to a community of faith where most of us don't get married and we want to consider what we're going to get when we get divorced, what is your argument?
Well, so my argument, I'm not sure. I told you it was a start, and I only had 10 days, and I don't have a very good answer to that. I think my argument would be something like, religious people share my faith in marriage, and we want marriage to pay the dividends that it pays, but we don't actually know why it does that. And I don't doubt that most religious people that have experience of marriage believe in fidelity, believe in permanence, believe in selflessness, believe all of those things. But sort of surrounding those norms are legal rules that put payment to those beliefs. In other words, think about the exit costs in some states. If you have children together, it would be a year in Virginia, right? If you don't have children, it would be 6 months. That's the state actually saying that we should be slower to divorce when children are implicated. And that actually pays dividends even to the religious people who find themselves sometimes having to divorce. And I don't mean this to be, by the way, a tirade against divorce. There are times when divorce is necessary in cases of domestic violence or adultery or other things that are not considered, that are considered deep breaches in the marriage. But I think those exit rules reinforce a religious norm, and my fear is if you unbundle those and you have exit rules over here and religious norms over here, that the religious marriages are impoverished, potentially. I'm not confident of that, but I'm dead confident that the civil marriages will be made worse from being divorced by religious norms. In effect, I think civil marriages, what little bit is left good in them, has been free riding on religious norms. They have been buoyed by religious norms. And I'm afraid if the religious marriage and religious people withdraw from the world, it will be to the worse for the marriage culture. So that's my basic premise, but it's more on this side than on this side.
And of course, there's a great irony in that, because many of the civil marriage people have not appreciated the extremely important value of the religious side of this joint civil religious compact that has existed and sustained marriage throughout history. They've really disregarded that and thought, well, what's the big deal? You want to do your Catholic marriage, go to your Catholic marriage. It's not really an issue for us. When in fact there has been this, again to use that terrible word, symbiotic relationship between the civil and the religious side that has bolstered marriage. And one of the big questions is what's going to happen to the marriage culture in the aftermath of the Obergefell decision. Are religious people going to be somehow repelled by this new civil marriage institution that includes same-sex unions, which they cannot agree to? And what's that going to cause them to think about and to feel toward the institution of marriage itself? And questions do arise about how then best to preserve the sanctity of marriage as an institution that guides men and women together for the benefit of their children.
Gene, you have the last word.
Well, thank you. I just wanted to say a big amen to both Robin's and Alexander's comments urging us not to adopt a position where we say, well, the state should just get out of marriage. I mean, the reality is that the state's involvement in marriage, despite the challenges that Obergefell poses, the state's involvement in marriage is very important to a large portion of the population, which, as we saw yesterday, is, they're probably only about half the people in the country who have any strong attachment to their faith. And so, and some number of those people have some, are going to listen to what the government tells them, even though they won't listen to what any faith tells them. And so people who are not strongly attached to religion need, I think, the state to continue to tell them, look, if you're thinking about having kids or you're thinking about doing anything that might result in having kids, you need to be married. And the more voices we have, the more credible voices we have in our society who are continuing to send that message, especially to young heterosexual couples, the better off we're going to be as a society. And to the extent that we withdraw any of those voices that are sending that message, we're going to be much worse off, and our children are going to be worse off.
And our religious liberty will be worse off.
Yes.
Because
Exactly.
the viability of religious marriage, of those who understand marriage as a religious institution and live it, is going to help to determine society's and the culture's response to religious liberty claims based upon those beliefs and based upon that conduct. If society views us as valuable and precious and doing great things, then it'll be far more likely to respect it.
Well, thank you very much. I think you can all join with me in expressing our deep appreciation for this outstanding panel. We will now have a brief break. If you'll come back in about 10 minutes, we would appreciate that.
Oh, absolutely, yeah, absolutely. I wanted to thank you. And I also wanted to being pro-life in your tribe, and that's
Highest fall.
and there has been.
Although they managed to sneak a few in anyways.
I've been active in pro-life since I was 15 years. There has been even in employment and hospitalization.
And even though there have been some, I mean, look, holding dissenting views is never possible. So